All right, we've got this breaking news just coming into our newsroom right now. The Supreme Court has issued a ruling.
This is a case that's been bounced around back and forth throughout the court system.
You ever hear about a case so big, so potentially earth-shattering?
There's a single sentence buried in a recent Supreme Court ruling that didn't make headlines, didn't generate cable news debates, and wasn't even the primary focus of the case being decided. Yet that one sentence, delivered unanimously by all 9 justices, has created what constitutional scholars are calling a legal time bomb for state-level restrictions on commonly owned firearms. While media attention focused elsewhere, the nation's highest court quietly reaffirmed a principle that now places numerous state prohibition laws on extremely shaky constitutional ground. This wasn't a Second Amendment case. The justices weren't directly addressing firearm regulations, but in establishing their legal reasoning, they restated a constitutional standard with such clarity and unanimity that it now threatens the legal foundation supporting various state restrictions. Meanwhile, in Minnesota, a completely separate situation is unfolding that demonstrates exactly why that Supreme Court statement matters so profoundly. Governor Tim Walz has called a special legislative session scheduled for October 6 through 12, 2025, with a predetermined agenda focused exclusively on passing comprehensive restrictions. The session structure is designed for speed rather than deliberation. No amendments unless all 4 caucus leaders unanimously agree. Entire agenda limited to predetermined topics. Bills already written and fast-tracked through committees before public input. This isn't standard legislative process. It's a compressed timeline engineered to minimize opposition and accelerate passage before sustained resistance can organize. What follows is an examination of what that Supreme Court statement actually says, why it matters for existing state restrictions, what Minnesota's proposed legislation would actually do, and why the collision between these 2 developments could reshape the entire landscape of state-level regulations nationwide. The Supreme Court standard that changes everything. The Supreme Court's unanimous statement reaffirmed what's known as the common use doctrine, originally established in the 2008 Heller decision and reinforced in the 2022 Bruen ruling. The principle is straightforward. The Second Amendment protects firearms that are in common use by law-abiding citizens for lawful purposes. If a firearm type is commonly owned and used legally, it receives constitutional protection regardless of whether legislators or judges personally approve of that ownership. Why does this matter? Because the most frequently targeted category of firearms, semi-automatic rifles with certain features, are unquestionably in common use. Over 24 million AR-15 platform rifles are currently in civilian hands across the United States. That's more than the number of Ford F-150 trucks on American roads. It's a larger population than the entire state of Florida. By any reasonable definition of common, these firearms qualify. State restrictions that prohibit ownership of firearms meeting the common use standard now face a fundamental constitutional problem. Courts applying Heller and Bruen are increasingly striking down such prohibitions, and the Supreme Court's recent unanimous restatement of this principle strengthens that trend. California has seen multiple restriction provisions blocked. Illinois is facing successful challenges. New York's revised framework after Bruen has been repeatedly modified through court intervention. The legal theory supporting state-level prohibitions has been progressively collapsing as courts apply the historical tradition test that Bruen established. Governments must now demonstrate that modern restrictions align with the nation's historical tradition of firearm regulation from the founding era or the period following the 14th Amendment's ratification. Blanket prohibitions on commonly owned firearms don't meet that standard, which is precisely why the Supreme Court's unanimous restatement creates such problems for existing state laws. The legislative process designed to minimize opposition. Minnesota's special session structure reveals a deliberate strategy to pass predetermined legislation before sustained opposition can organize effectively. Special sessions operate under different rules than regular legislative sessions. They're typically reserved for genuine emergencies requiring immediate action, natural disasters, budget crises, urgent matters that cannot wait for normal legislative calendars. Using a special session for predetermined policy implementation that's been planned for months serves a different purpose. It compresses timelines that would normally allow for extensive public hearings, committee review, amendment proposals, and deliberative debate. In this case, the entire session could last as few as 4 days. Committee meetings are being scheduled with minimal advance notice. Public testimony opportunities are severely limited. And crucially, amendments cannot be introduced unless all 4 caucus leaders unanimously agree. a procedural barrier that effectively prevents any modifications. Bills have already been drafted and circulated among legislative leadership before the session even begins. This isn't how legislation typically develops, where proposals get introduced, refined through committee process, amended based on testimony, and modified through floor debate. This is pre-written policy being pushed through using procedural mechanisms that minimize opportunities for opposition or modification. The absence of a state-level equivalent to the Second Amendment in Minnesota's Constitution creates an additional vulnerability. While the federal Second Amendment applies to states through the 14th Amendment, having explicit state constitutional protections provides additional legal recourse through state courts. Minnesota lacks that additional layer, making federal constitutional challenges the primary avenue for legal opposition. What the proposed legislation actually does: the Minnesota proposal isn't a modest regulatory adjustment or a targeted response to specific problems. It's a comprehensive restriction package that fundamentally alters what residents can legally own and how they can exercise rights that are constitutionally protected at the federal level. The legislation includes complete prohibition on semi-automatic rifles with certain features, specifically targeting AR-15 platform rifles and similar designs. It establishes criminal penalties for possession of magazines exceeding 10-round capacity, even for individuals who legally purchased them years ago. It bans binary triggers, bump stocks, and forced reset triggers, devices that alter firing characteristics. It prohibits unfinished receiver kits, commonly called 80% lowers, and all privately manufactured firearms. It expands so-called red flag laws, allowing firearm removal based on subjective concerns, and it allocates millions for public campaigns promoting these restrictions. These provisions don't grandfather existing ownership. Law-abiding citizens who legally purchased items now being prohibited would face several unappealing options: surrender the items, render them inoperable through permanent modification, store them out of state, or face criminal prosecution for continued possession. There's no compensation mechanism, no buyback program, and no extended compliance period. The legislation treats peaceful citizens who own common items as de facto criminals based solely on continued possession of property that was entirely legal when acquired. The magazine capacity restriction is particularly problematic from a common use perspective. Standard capacity magazines, typically 30 rounds for AR-15 platform rifles, are the factory default configuration for these firearms. Hundreds of millions of such magazines exist in civilian hands. Defining standard capacity as large capacity and prohibiting them doesn't change the constitutional analysis. These are common, widely owned items used lawfully by millions. The red flag expansion that eliminates due process. The proposed expansion of restraining order provisions represents a fundamental shift in how rights can be restricted. Traditional legal standards require due process before rights are curtailed: notice, opportunity to be heard, presentation of evidence, right to counsel, burden of proof on the government. Emergency provisions sometimes allow temporary restrictions with expedited hearings, but even those maintain some procedural protections. The Minnesota proposal expands who can petition for restrictions and reduces evidentiary standards for granting them. Non-family members with limited knowledge of the individual can initiate proceedings. No criminal conviction or even criminal charge is required. Firearms can be removed before any hearing is conducted, with the burden then falling on the owner to prove they should be returned. And state funding is being directed toward public campaigns, specifically encouraging use of these provisions. This inverts traditional legal principles. Instead of the government proving someone poses a danger, individuals must prove they don't. Instead of requiring concrete evidence, subjective concerns become sufficient. Instead of due process before restrictions, confiscation occurs first with hearings later. These procedural inversions create obvious constitutional problems under the 14th Amendment's Due Process Clause. The data that doesn't support the policy: when similar comprehensive restriction packages have been implemented in other states, the actual results have consistently contradicted the promised benefits. Connecticut passed an extensive registration requirement in 2013 following a high-profile incident. Compliance rates were estimated at 15% or less. The vast majority of affected owners simply ignored the law. New York's SAFE Act produced similar results, with compliance estimates ranging from 10 to 15%. Studies examining whether these laws prevented subsequent incidents found no measurable effect. California has implemented some of the most comprehensive state-level restrictions in the nation over decades, Yet research examining whether these provisions reduced relevant incidents or changed patterns has consistently found minimal or no measurable impact. FBI uniform crime statistics show that rifles of all types, including those being targeted by these restrictions, are used in fewer incidents annually than knives, blunt objects, or even bare hands. The category being targeted simply doesn't represent the primary source of the problems these laws claim to address. If empirical evidence doesn't support the policy effectiveness, why pursue it? Because political symbolism often matters more than measurable outcomes. Being seen as doing something provides political benefits regardless of whether that something actually works. And restrictions on politically unpopular items generate supportive headlines even when compliance is minimal and impact negligible. The national coordination behind state actions. Minnesota's legislative push isn't an isolated local development. It's part of a coordinated national strategy funded and organized by advocacy organizations operating across multiple states simultaneously. National organizations with substantial funding have publicly endorsed Minnesota's approach and are working to export the model to other jurisdictions. Similar proposals are being developed or have already been introduced in New Jersey, Oregon, Maryland, and Washington. Legislative language is being shared across state lines, with Minnesota's draft provisions appearing in proposals elsewhere. This coordination means that Minnesota isn't just making state policy, it's serving as a test case for a national strategy. If comprehensive restrictions can be passed quickly in Minnesota using compressed special session procedures, that playbook will be replicated elsewhere. Other governors will call special sessions. Other legislatures will use procedural mechanisms to minimize opposition. The strategy will spread because it worked, not because the underlying policy is sound or constitutional. The legal challenges already being prepared. Constitutional advocacy organizations are preparing challenges to be filed within hours of any legislation being signed into law. These challenges will argue violations of the Second Amendment under Heller and Bruen standards, violations of the Due Process Clause for criminalizing previously legal property without compensation or hearings, violations of the Equal Protection Clause for arbitrary categorizations, and potentially First Amendment issues regarding restrictions on sharing information about manufacturing. Several federal judges in the relevant circuit have recently ruled favorably on challenges to similar restrictions, suggesting a receptive judicial environment. Courts have been increasingly willing to block enforcement of state restrictions while constitutional questions are litigated, preventing immediate impact while legal challenges proceed. But here's the problem. Even unconstitutional laws cause damage while they're being challenged. People face prosecution, property gets confiscated, rights are restricted. Years can pass before final court rulings restore what was taken. The process itself becomes the punishment, regardless of ultimate legal outcomes. So here's the collision that's happening right now. The Supreme Court just unanimously reaffirmed that commonly owned firearms receive constitutional protection, creating serious legal problems for state prohibition laws. Simultaneously, Minnesota is using compressed special session procedures to pass comprehensive restrictions, specifically targeting those commonly owned firearms with minimal public input and predetermined outcomes. National organizations are watching Minnesota as a test case for exporting this model to other states, and constitutional challenges are being prepared to file immediately upon passage. The next few weeks will determine whether Minnesota successfully implements restrictions that directly conflict with unanimous Supreme Court guidance, whether courts will block enforcement while challenges proceed, and whether other states adopt Minnesota's procedural playbook for quickly passing predetermined restrictions. What happens in one state over the next month could reshape the entire national landscape of state-level regulations for years to come.